Peas on Moss is brought to you by Kimberly Schaub, a culinary scientist turned business developer. Over the past 4 years, the audience has downloaded episodes over 40,000 times, and we have 1,500 impressions across the website and a host of social media platforms. Will you consider contributing to the show to help keep it on air? Donations through Patreon help to offset the cost of web hosting, editing, and producing the various Peas on Moss offerings, from podcast episodes to videos, and every little bit helps. From corporate advertisement to sponsored content and private contributions. Reach out to me on peasonmoss.com for details. Welcome to a new, really large, not so quick bite episode, Peas on Moss podcast listeners. Thank you so much for joining me for each episode. I'm your host, Kimberly Schaub, a research chef turned business developer. This week, I'm bringing back our favorite food business lawyer, Abe Cohn. Abe is the managing partner at Cohn Legal Group, a specialty group of a larger law firm designed specifically to provide a boutique and highly individualized experience for entrepreneurs and startups in the food space. They have offices in New York and Massachusetts. Abe gave us a really fantastic Legal 101 in 2019, and he is back by popular demand. I pitch all sorts of questions at him, and I decided to share this entire recording because I couldn't really decide which portions really encapsulated the whole conversation or might resonate more with you. So here it is, the full unabridged interview with Abe Cohn. At the end of the episode, he generously offers free consultations for Peas on Moss podcast listeners. So if you're an entrepreneur, a consultant, or a food professional who might deal with contracts, you may benefit from giving him a call. Let's get right into the episode. We started talking about contracts, I think, a little bit with working with outsourced resources, whether that is a contract manufacturer or co-packer. I've been a consultant myself. And so I wanted to kind of dig into that a little bit because, I have an ability in food science and food product development, but when it comes to writing up a contract, that is very much not my space. I was wondering if you could kind of set the stage for us of why it's important to have an effective contract in place.
Yeah, absolutely. Even before getting to the contract stage, one thing I always advise my clients, and sometimes, people tend to skip over this, but as a general rule, before entering into a contract with anybody, make sure that you have set up the appropriate business entity. So at the very onset of a company's development, a founder may be tempted to kind of skip this step, and then they find themselves jumping into some sort of new agreement. But it's critically important that a founder or an owner never enters into an agreement with another company as that owner. Instead, they need to be entering into the agreement, into the contract, under the purview of their business entity, whether that may be an LLC or a C Corp. And the idea there, of course, is that the owner wants to maximize his or her protections against any sort of personal liability claims. So that is kind of rule number one. Before you enter into an agreement or contract, make sure you have a business entity set up and you only sign that contract or agreement under the name of the business entity and not under the individual's name.
Let me pause you there. Why?
Well, so imagine for the moment if you entered into a contract with somebody and you didn't have a business entity set up, and 6 months in, something bad happens, whatever that may be. And there's a universe of bad things that could happen, and unfortunately very often do happen. But if the owner enters into the contract under their own personal name instead of the name of the business entity, then that owner's own personal assets are potentially liable and open to seizure. So you could be sued, and your own bank account, whatever in there, that could be up for grabs. Conversely, if you enter into the contract under the business entity, then only the assets held by the business entity could potentially be seized or implicated somehow. So that's why it's important to always enter into contracts as a business entity and not as an individual.
Okay. All contracts, I assume.
Correct.
Okay. let's pull back a little bit as well and talk about NDAs. Can you give me kind of a rundown on the types of NDAs? I know I've heard terminology of CDAs, mutual NDAs. Are
Yeah.
you able to share a bit about that first?
Yeah, absolutely. So an NDA is a non-disclosure agreement. Um, Mutual NDAs are simply non-disclosure agreements that are signed by both parties. And the idea is that in communicating ideas about the proprietary nature of one's business or invention or product or whatever it may be, um, you want to make sure that the person who you're communicating these ideas to is agreeing in writing that they're not going to use the idea in any way. They're not going to take the information and misappropriate it. Now, look, the reality with these NDAs is that they're tremendously difficult to enforce. And I think they need to be done, but very oftentimes there is something kind of perfunctory about it, unfortunately. Typically, I recommend my clients to only enter into, quote, NDA relationships with those people that are actually trustworthy. I mean, an NDA is a minimum level of protection. Again, one that I think all companies should put to use. But if you enter into some sort of relationship with an untrustworthy person, an NDA probably isn't going to do that much good.
Interesting. Okay. I will shelve the commentary on human nature, perhaps.
Yeah.
But okay,
that
so
might be a bit of a cynical attitude, but it's the truth, unfortunately.
Unfortunately. So when we start talking business with another entity, whoever that is, do we automatically go into an NDA, or is there a certain threshold of information that would trigger invoking an NDA, if you will?
Yeah, the default rule should be have them sign an NDA. And the reason is that NDAs are fairly simple, easy to put together. They don't require any sort of burdensome action on the part of the signee of the NDA. So, requiring the other party to sign one, both, like I said, offers some sort of preliminary level of protection. Plus, also, I think more importantly, it sets the stage for a very professional relationship, and it shows that you mean business. You're a serious party, and I think that's important for any sort of business undertaking.
That resonates completely. Okay, so NDAs are signed. We have set up the right business entity by reaching out to an organization or a firm like yours, registered with the state, etc. Let's talk about the next steps from here.
Sure. So at this point, and we touched upon this briefly the last time, you want to make sure all of your branding assets have the appropriate protection vis-a-vis intellectual property. And just as a quick recap, again, listeners can revert back to the previous podcast for an in-depth discussion about this. But any new invention, product, system is governed by patent law. Branding items, which typically consist of names, logos, and slogans, are governed by trademark law. And works of creativity, works of authorship, books, drawings, graphical representations, all of that is covered by copyright law. So you want to make sure all of your intellectual property assets are covered. Once that's done, so at this point, I think we can reasonably say that the fundamentals of the business are kind of set up. Business entity is done. Mm-hmm. The contracting party has signed an NDA, so you can freely discuss whatever it is that you need to discuss with them, depending on what your relationship to this vendor is. All of your intellectual property is now secured. And now you need to kind of dig into the weeds of developing your product. Perhaps that's manufacturing or production, or developing a marketing plan. And, from here, the option tree diverges according to what your business is all about. So different businesses are going to have different legal requirements.
Okay, so let's dig into that a little bit. Is this the point that I would say I should call my legal counsel / call Abe. Or what if a business owner or founder is wanting to be as shoestring budget, hustler as possible, where can we see kind of the best spend of time and resources versus outsourcing to the experts in this subject?
Sure. Well, again, I think it really depends on the business. Certain types of businesses require more complicated legal work. I can tell you, just for example, different states, depending on the industry you're in, require different types of licensing. So as this pertains to the food industry, if you wanted to, example, open up a butcher shop, you can imagine there are a lot of kind of complicated licensing matters that have to be addressed, both with the USDA and on a local level, having the right permits. So that is the sort of thing that I would recommend not skipping out on. Not trying to save money there. The food industry is unique because of how much faith the target consumer has in the producer. So cutting corners in general is not recommended for companies that are selling things that are ingested or taken by a consumer, medicine, food, anything that poses a potential safety hazard. That kind of thin slice area of the business should definitely not be cut out from kind of the professional purview of an attorney. Areas to something like an NDA. I think that would be the sort of thing. Again, not such a complicated matter. A crafty startup veteran would certainly be able to put one of those together without having to hire an attorney. Although for very complex intellectual property matters, you might very well want an attorney to hire in order to draft the appropriate NDA. But look, as a general matter, the question really is defined by how risk tolerant or risk averse the founder is. If the founder is more risk tolerant, then he or she will find himself or herself cutting more corners, which may be fine. But if they're not, then it's worth spending a little bit more and sleeping a bit easier that night.
So kind of what I'm hearing is that the legal counselor and attorney consultant firm is sort of part of the product development or food business team, even if you're not necessarily a full-time employee, that a food business, especially one that expects to grow or is taking on perhaps a food category that's considered higher risk because of the type of food product it is and how it influences high-risk populations, that the attorney is part of that kind of extended resources group, essentially.
Yeah, and as a good example of this, I am an outsourced general counsel for a startup. I'm not going to say which one, but effectively I'm retained for a certain number of hours every month on a flat fee, and I sit in on phone calls and I draft emails, and ultimately, my job is to make sure that this particular client is not being taken advantage of, and that comes in many different forms of contact with vendors and other consultants and contractors. But ultimately, I think it's important for a founder or a team of founders on a startup to identify in a very real way, how risky of a proposition it is, what they're selling or what their business model is, and take the appropriate legal precautions.
Okay. So let's talk about kind of that business structure really quick. You said you're a general counselor, an outsourced general counsel for a startup, and you have a retainer agreement with them. How does that work versus engaging you for specific types of activities?
Sure. So in the event, let's take a simple example, like a trademark. A new startup company has developed its brand. They don't have a huge amount of capital, nor do they have a robust need for legal counsel, but they do need to have someone properly vet their prospective trademark, take care of all the filing and application aspects of the registration process. So that would be a perfect example of a type of scenario that would warrant a one-time engagement where they would just hire me to manage the trademark application. That's it. For clients that are doing more complicated things, and again, we're kind of speaking very abstractly right now, but for an operation that has a lot of moving parts and different vectors of potential liability and dynamic events that are happening in real time, and a lot of different outsourced vendors coming in and helping with different things, you could imagine that a more ongoing relationship with legal counsel would be helpful in that event. So in this particular, large companies typically have in-house counsel. They have an attorney or a team of attorneys, depending on how large the company is, whose sole job is to just manage the legal aspects of running a business. For startups, naturally they can't afford to have an in-house general counsel. So instead, under this business model of an outsourced general counsel, they have the advantage of someone who's kind of intimately familiar with the business and the business model, who knows the founders, who's working with them hand in hand, but is still, outside of the company, not on the payroll, in an employee capacity. And it's really quite a good system if you're the right type of company.
Yeah, thank you so much for that explanation. I've definitely seen different versions of it, of a relationship with general counsel in the different types of companies I've worked for. And I have to say, and I feel like we are friends at this point, and I still find general counsel hat so intimidating.
Yeah. Well, there's a lot to know.
Mm-hmm.
And what's interesting about the legal field in general is that there's so many aspects and sub-aspects and idiosyncratic laws. So, I wouldn't be a general counsel. I wouldn't be a good candidate for an outsourced general counsel for a real estate firm, for example, because I don't practice real estate law. And similarly, there are many other areas of law that, frankly, I don't have any experience with and don't know anything about. And I would be mortified to find myself in the position of an outside general counsel for that too. But in general, someone like myself practices a lot of corporate transactional work and intellectual property work. Working with different startups is something, again, I feel quite comfortable doing. And, the more you do it, like anything else, the more and the more comfortable you become with dealing with kind of interesting and new legal issues.
Speaking of those, I'd like to dig into some tough questions that I'd emailed to you.
Okay.
But like months ago. So we'll just rely on your staying on your toes with these questions. Let's talk about accidental copyright infringement. We talked at length about this on the last podcast, and I'll certainly share the link so folks can go back and listen to the basics kind of copyright law. But recap quickly for us what that legal counsel search sort of looks like when we're coming up with a concept and want to make sure that we're not literally reinventing the wheel and infringing on someone else's patent or copyright of some sort.
Sure. Okay, so the first thing is to understand where the matter of copyright infringement could potentially come up. So as I mentioned earlier in this podcast, there are different types of literary and creative works that are implicated by copyright law, but and copyright law and trademark law has kind of an interesting interface at certain points. So as this relates to the food industry, let's just consider what would be a good example? Something like the cereal Frosted Flakes, which I'm sure you're familiar with.
Mm-hmm.
So you have Tony the Tiger, right? You go to the store, you see a box of Frosted Flakes, and there's that kind of iconic blue background with Tony the Tiger with his bulging muscles. And when you look at that, you just know immediately that you're staring at a box of Frosted Flakes, right? So if a new startup food company were to come along and replicate that box and the design of the box and all of the graphical elements of it, they would actually, interestingly, likely be violating both the copyright of the corporation which owns Frosted Flakes. I think it's General Mills, I don't know. But also not only the copyright of it, but also the trademark. So those elements, Tony the Tiger specifically, would be a good example of something that is both a copyright and a trademark. It's a trademark because when you see Tony the Tiger with his muscles, and I'm trying to remember what he typically wears. He has some kind of outfit.
He has a bandana, maybe?
A bandana, that could be, yeah. So when you see that image, you just immediately understand that you're looking at a cereal box of Frosted Flakes from General Mills, right? And that really is the essence of trademark law. It's a symbol that when tethered to goods or services, in this case, cereal, immediately alerts the consumer to the proprietor of the company which is producing that good or service, General Mills. So a new startup in the food space that copied it would be violating their trademark. Simultaneously, that cereal box has all sorts of interesting graphical imagery on there, graphics and whatever it looks like, I don't know, but it looks a certain way, right? And that creative expression, which was developed by the General Mills company, is protected by copyright law. So that's why a person would potentially be violating both copyright and trademark. So, that's where this issue of copyright infringement would come up. Anytime a person has taken somebody else's words, if someone, the reason why you're not allowed to just write a book with a chapter of the Harry Potter story in it is because J.K. Rowling owns the copyright on it. Similarly, you're not allowed to copy the front page of any of the books because she has the copyright on it. Any of the music that's in the Harry Potter movies is owned with copyright law. So, that's kind of where some of these issues come up. Does that answer your question?
Yeah, I think it does. And again, folks who want to go deeper into this from an overview perspective can certainly listen to the last episode, but definitely reach out to Abe. He's definitely helped clarify information in my head as I understand businesses as well. So shameless plug for Abe because, this is, it's important for us to understand the business that we're in and the risk level tolerances that are part of the business. And then, your own personal experience, depending on what you've had in other professional settings. So I think that's an important differentiation. I appreciate that you went through that.
Great, thank you.
Question then, the next question that I have is, what do you do if you receive a cease and desist letter? Firstly, what does it mean other than sounding utterly terrifying? And what are the actions required?
Sure. So I can tell you that I have been both on the receiving end and on the sending end of a ton of cease and desist letters. And more often than not, they're meant to compel, for the very reason you just alluded to, that they are, at least to the untrained eye, terrifying, right? They're full of legal language and scary threats. But basically, the idea of a cease and desist letter is to compel the recipient of a cease and desist letter to stop, to cease, and desist, and a fancy word for saying stop again, to stop doing whatever it is that the sender of the cease and desist letter is accusing them of doing. Now, the degree to which a person should be concerned when they receive a cease and desist letter is a function of a number of things. One, I think the seriousness of the cease and desist letter. Sometimes, you might get a cease and desist letter and it's obvious that the sender just took something off the internet and it doesn't really relate to what you personally, the individual receiving it, have done or are currently doing. And unfortunately, you have cease and desist letter trolls who maybe, they try to scare someone and say, well, just give us X amount of money and we'll leave the matter be. So, if you get something like that, chances are nothing bad's going to happen. Again, depending on how risk averse you are or tolerant, you might decide to contact an attorney or just do nothing and see what happens. If the cease and desist letter kind of feels more professional, interestingly, as a bit of an aside note, a famous Supreme Court justice, Justice Potter, said about pornography, you know it when you see it. And the standard there,
interesting.
That idea is meant to kind of encapsulate how to approach kind of immaterial observations, not necessarily based on real sets of evidence, but you look at something and you just kind of know, is this serious? Is this something to worry about, or is it not? So certain people have better intuitions about that than others. But I think that holds true for cease and desist letters. Sometimes, I've gotten cease and desist letters that clients have sent me, and you could just tell that, they're not serious. They're not something to worry about. But other times, you got a very serious cease and desist letter, and you might also know that maybe you did violate either a person's trademark or their copyright, and now you have to start working through the letter and seeing what's exactly being demanded. And at that point, you certainly would like to speak to an attorney.
Yeah. Okay, so let's talk about this kind of attitude that I have heard mentioned. I guess I'll chalk it up to bravado potentially, but an attitude of we'll apologize later, or no one has stopped us yet. Can you talk us through that attitude a little bit? Kind of putting on your general attorney hat without any specifics, of course.
Yeah.
But what about that attitude?
Well, look, it's certainly cavalier. And as a general matter, I do like that attitude for entrepreneurs and startups as they undertake difficult tasks and goals that other people might tell them they can't do. So as a general kind of meta attitude, I full-heartedly approve and endorse it. As far as that attitude applies to the receipt of a cease and desist letter, I think, frankly, it's a bit too aggressive. I mean, the reality is that copyright infringement in particular is a very serious matter. The court takes it very seriously. And the monetary damages associated with copyright infringement are again, very serious. So a person who thinks that should do so at his or her own risk.
Understood. And kind of to your point, as you've iterated throughout all of these questions, it really depends on the business and the founders' kind of work that they're doing and experiences they have. So it is kind of hard to speak in broad sweeping terms on something that's very specific very quickly.
I can actually give you an example from last week.
Okay.
A client of mine, they run a social media company on the web, of course, and they're continuously uploading new posts to their blog. And unfortunately, as was detailed in the cease and desist letter that he got, he used a picture that he just found on Google, through the search engine. And the owner of that picture sent him a very nasty cease and desist letter, saying that he didn't have the right to use it. He put it up there, and then they're demanding not only the immediate removal of the picture from his blog, but also a certain amount of money, which right now we're kind of working through and hopefully trying to settle for a lot less money than what they're asking.
Ooh, that's interesting. And that let's spend a little bit of time on that. Obviously, I have a blog and a podcast, and I'm very careful with the imagery that I use, that it's not copyrighted by someone, because I feel very strongly that artists and professionals should be reimbursed for the expertise and work that they do. And at the same time, there is a lot of content available that we can copy. So talk us through a little bit about that. If we were writers how do we have to go join a photo membership, or what are some good practices to employ?
Sure. Well, as a general matter, I don't think writers necessarily need to worry about this quite as much because, typically if you're a writer, if you're coming up with a creative expression of your own idea and work, right? What's more common, unfortunately, is kind of this notion of innocent copyright infringement, which I think which is what you asked about. A person doesn't maliciously start out the day thinking he wants to just go rip off somebody else's work and their photographs, but it could be that a person just isn't entirely aware of what copyright infringement is about and what sort of licenses a person may need in order to take a picture that they perhaps innocently find on the internet. Basically, there are a couple things to understand about copyright law, but it's a very large discussion, obviously. So I just want to think about how to boil it down to the most essential points. As a general rule, okay, the moment something pops out of a person's head and onto a piece of paper or into a material form, if it's a sufficiently creative work, it has a copyright. So unlike a trademark, where if you wanted a trademark that would apply all throughout the United States, you need to have a registered trademark through the USPTO. With copyrights, a creative artist is immediately conferred a copyright. They have a copyright the moment it's put into existence. So that's kind of an interesting idea. But as far as the limitations of enforcing that copyrights, even though they exist at the moment of creation, they need to actually be submitted to the Copyright Office in order for them to be enforceable. And there are a lot of different legal nuances there, so I don't necessarily think we should go into that. But assuming for the moment that a person does hold a valid copyright and someone else infringes their copyright by either directly copying the work, or, and this is again a kind of a nuanced discussion, but if a person were to use a derivation of that copyright, so just imagine the Harry Potter story that's tweaked just a little bit so that it's not an exact copy of the story, but clearly it's a derivation of the Harry Potter work, right? That's also impermissible. So, in that case, the infringer has to both pay, if they already get sued, the actual dollar amount of the damages and profits, the mechanics of which are organized and figured out according to each case. But then the law provides for a huge amount of monetary damages also, upwards of something like, I think it's maybe $150,000 potentially.
Wow.
So there's really a lot of money at stake. So, if you didn't create the work and you didn't create the work, make sure that wherever you took it from explicitly provides provisions of how, when, where, and why you're allowed to use that work.
Mm-hmm. Wow, that's so powerful. It's so easy to just grab a cool looking image, whether that's a meme or a logo even of a brand. And I have to be careful when I request brands logos from my guests. I have to make sure it's something that they've sent to me, that their marketing and PR teams have approved for use. So that awareness is key. And being a creator, whether that's the blog or whether it's product development, that's work that somebody put into it. And so respecting that and, getting the permission to use it.
There is one important caveat, which I think is worthwhile mentioning, which is a legal doctrine called fair use. So like we said, if a person has a copyright, you're not allowed to reproduce it, distribute it, or even develop some sort of reproduction, a derivation of that work. But under this legal doctrine of fair use, there are certain types of usages of copyrighted works that are in fact permissible. So satire is like a classic example of that. If you were an artist and you had some interesting observation about Nike, let's say, It could very well be that if you were to take Nike's logo or, some Nike digital asset and you were to reproduce it, but then you kind of transformed it to represent a satirical purpose, then even though traditional copyright law says that you're infringing on their copyright, the doctrine of fair use law says that your satirical representation of Nike's digital assets is actually exempt from traditional copyright law. And that goes true for any sort of criticism or comments, or if you're teaching, there are all sorts of interesting cases about this. If you were a food scientist, for example, and you had a class of students in there and you're teaching different aspects of kind of the art of food science, and you were to just bring in other people's work, but only for the purpose of teaching, then that might be a clear case of a fair use exemption. So you can imagine a lot of copyright litigation surrounds what exactly qualifies as fair use and when it does not.
Ooh, that's very interesting and does sound kind of nuanced and looking at the intent of the content.
Absolutely.
Okay.
Yeah. And one key point to keep in mind, just as a litmus test, the more if the user of the prospective work makes a lot of money from it, it's much more challenging for him or her to claim fair use, because then you're really profiting off the creative work of someone else. If, however, you're not really making any money off it, then it does seem kind of more, quote, fair to allow them to use it as some sort of social commentary or a satirical work or something like that. So that's just a good point to keep in mind.
Thank you for that. Yeah, it's always interesting to see how the size of a business or profits made from something inform how these conversations go, it seems.
Yeah, absolutely.
So I have a question then, I think that folks may send over in our direction is, does your firm address food safety or FDA regulations or violations potentially? Or is that a different type of attorney and firm to approach?
Yeah, it does absolutely. I have a lot of experience with food labeling law, which is a very interesting area of the law. You really see that come into play with startups, food startups that are kind of in the fruit vegetable sector. So, is this fruit or is it fruit concentrate? All this kind of stuff. And then the FDA, again, anytime you're dealing with food, the details really matter. So this is something that I really enjoy working on. I'd be happy to speak to any of your listeners about.
Excellent. Thank you. I was surprised to have conversations about the intent of an ingredient in a product, and clean label organizations certainly ask, why is this preservative or this ingredient in a product? And so that's one type of question. But really, when it comes to the added sugar labeling, I think that's the one that gets very confusing, especially when we use, in my case or my experience, using fruit paste or concentrate to contribute flavor, but is it contributing sweetness? And I think that's a sticky wicket, right?
Yeah, and this is where working with an expert food scientist is really important. I mean, you really need to know what is going into your product.
Yes, absolutely. And I think this is, again, kind of to loop back to what a product development team looks like, or what a food businesses team or outsourced resources can look like. Having an expert on the food science and technology, as well as general counsel, they are part of a core team, even if they're not necessarily on your employment payroll.
Absolutely. An essential part of the team, without a doubt. And, you really want to make sure everything is documented. So the food scientist sends you an email and says, hey, we're making a change to this. Don't just ignore that. Put that in your portfolio of documents and keep everything as neat as possible.
Yeah, absolutely. We'll have to do another episode on documentation tips and how to stay organized, because At the pace that emails fly at our heads, and I imagine for you it's quite complex,
Yeah.
making sure those go into the right folders to be accessed again quickly
Yep.
is a magic trick of its own.
Definitely. Definitely.
Wow, Abe, this hour has just flown by. The
Yeah.
value and the content that you share every time has just been mind blowing. I take so many notes. It's crazy.
Wow. Thank you so much. Wow. That's very nice.
Thank you. I really appreciate your service here as far as providing some baseline information. And folks, please again, find an attorney whose experience and expertise meets the needs of your business. Please don't go it alone. Abe, thank you again for being our voice of legal for the Peas on Moss audience. I'm grateful that our community has benefited from your expertise.
Excellent. Yeah, my pleasure. Thank you so much. I love the food industry. I'm often asked, why the food industry? And the reason is that, people don't just find themselves here. You're in the food industry because you love what you're doing. These are entrepreneurs that are passionate about developing products that are healthy, that are clean, and this is increasingly so. It's really a pleasure for me to be a part of this community. So thank you very much for having me on here. And just lastly, of course, anyone who is interested in speaking with me, I would love to chat with you. Consultations are entirely free if you just mention that you came to us through this podcast. And I really encourage everyone to send over questions, comments, or any way we can help. We would love to, really.
Thanks for listening to this long and very important podcast this week. I'm excited to continue inviting you into these conversations. I hope you find them valuable. So let me know what you think. Drop me a line at peasonmoss.com or find my Instagram. Look for Peas on Moss. Talk to you again soon.